We will now start session 4 on the topic of delivering the best in arbitration, areas to focus in future. Let me now introduce the distinguished moderators and the panelists. As moderators, we now have Mr. Nakul Dewan, MCIA Council Member, Counsel of 20 Essex Street, and Mr. Stephen Lim, Senior Partner of CAMS Singapore. And as speakers, we have Dato Nitin Nadkarni, Partner of Lee, Hishammuddin, Allen and Gledhill, Ms. Kalindee, Mehta, General Counsel and Corporate Secretary, SAP, India Subcontinent, Mr. Montek, Mayal, Managing Director, FTI Consulting, APAC, and Ms. Shaneen, Parikh, Partner of Cyril Amachan Mangadas, Mumbai, and Mr. Sitesh Mukherjee, Partner of Trilegal. I'm handing this over to the moderators, please.
Thank you so much. So I'm sure since most of this crowd has sat through this conference the entire day, and you've gone and seen how the moderators have effectively led the sessions, let me tell you what we've decided to do. We've decided to spin it the other way around, where it's actually the speakers who are going to lead the moderators. And I'll tell you, that's not by choice. That's absolutely because we've been browbeaten into doing this. And it all began with Niti. So when I told Niti we're in this session, we're in the graveyard session, and we need to do something exciting, and she said, what do you want to do? And I said, let's do coffee with Karan. She said, I'll get you the coffee, I won't get you Karan. So out went that. And that's exactly what we wanted, and we didn't get it. Anyway, so then I said, okay, the only two people on this panel who I think I can browbeat would be Shaneen and Montek, and I said, listen, we've got to do something different. We're going to do a debate. And they said, absolutely not. We're not doing a debate, we're doing a discussion. So out went that.
But
so,
nice of you to tell them.
we had to, right? So Stephen and I said, listen, this is just not working out. And we've decided that the manner in which this panel session is going to work is that the speakers will do whatever they want to do. And at some point, at the end, we're going to come and wrap this up. And just to sort of help get these proceedings kick-started, we're going to begin with Sitesh. I have nothing to tell you about what he's going to say. He's going to introduce the topic. He's going to he's going to get the ball rolling, and we will wait and watch. Sitesh.
We are going to do a scripted, unscripted performance. So the director is right beside me, so you have no cause for worry that he will keep us all at a tight leash. So my topic in this session is on proactive arbitrators. And when we talk about proactive arbitrators, the focus invariably is on what role the arbitrators could play in facilitating a settlement between the parties in course of arbitration. Arbitrations are becoming increasingly expensive, as a lot of us have been speaking about, and oftentimes there is a solution which is writ large, which many of the parties, the arbitrators, can see once the pleadings are in, once a certain minimum level of documentation has been done. So, can the arbitrators have a role in facilitating a settlement? Obviously, there's a doctrinal debate between civil law and common law immediately, which springs up on this issue. Because in civil law countries, with its inquisitorial systems, where the tribunals lead the discussion and the matter mostly, they are more comfortable with this kind of an approach. Whereas in common law, we start, doubting things if arbitrators or judges take a disproportionate interest in the outcome of the case. We want them to just listen to us and then decide on that basis. That's how we are trained. Now, I'll leave aside the doctrinal discussion for a while, but actually focus on two practical issues which could reduce the area of doctrinal dispute on this matter. The two practical difficulties, the way I see it, one of them is obviously that there's little alignment between the economic interest of the arbitral tribunal with an early settlement. So in the last conference that I did, I heard a speaker saying that the parties got into a settlement and he received an email from one of the arbitrators. The arbitrator did not know that he was addressing everybody, but and in fact, he wrote to his brothers saying it's a shame that the parties are settling. So yeah, and I must say that if I were an arbitrator, we're looking at a huge fee at the end of the proceeding, I would feel a little jilted if the things got settled quickly. So therefore, the first thing is that we need to align the economic interests of the arbitrator with an early settlement process. Now, here's a fact. ICC did a study where they found that 83% of the costs are actually party costs. 15% of the costs are arbitration fee and 2% is the administrative fee. So if we could have an incentive structure which allowed a little more leeway in that 15% to the arbitrators, even in case of settlement, I guess there would be alignment. As of now, most rules provide for a refund once the settlement happens. And sometimes, and this is a personal experience, after the settlement has happened, the parties don't want us aboard in terms of the settlement because that may lead to a higher fee. So they feel, well, there's a settlement, we'll enter into another arbitration clause in the settlement, and if the settlement goes bad, we can start another arbitration, but save some fee for the, for the present, on the basis of the settlement. So that's one thing that we need to look at. But the more complex problem is when the arbitrators decide to get into persuading the parties into a settlement, what should they be doing? Should they be just suggesting it to the parties? Should they be actually directing the parties to have some settlement sessions? Or should they actually play a more active role and start having a settlement conference, leading a settlement conference, caucusing with both sides to see where is the common ground? Now, the major problem as a common law practitioner that I feel I'm very uncomfortable with is that, when the arbitrators start playing mediators in the middle of the arbitration, obviously they are forming some notions about the matter. And they're forming notions about the matter, they're forming notions about the party's stand and stridency, which I would think is avoidable. One could actually get over the problems. The Singapore model of ARB mid ARB seems to be an interesting one, where you can have the arbitration started, then after the pleadings are complete, you could actually have another mediator, independent mediator, look at the possibility of a mediation. And if it doesn't happen, then you proceed with arbitration. But that of course, is something that could have more teeth and have more weight if, in fact, the arbitration, the mediation report, in case the matter didn't finally get settled, could be looked at by the arbitrator at the stage of awarding costs. So if a party who could have settled a matter with, under the supervision of the mediator does not do so and ends up losing, I think he should have to face a little more higher cost. And that would give some weight to this process. That would make parties more buy into the process, because as of now, if there is no downside to not agreeing in a mediation process, parties may not consider it actually something that is worth doing. Besides this issue of mediation, conciliation role of arbitrators, parties themselves could actually do themselves a favor by going for a well-designed arbitration clause with defined rules, like some of the problems that we've been hearing since morning. Defined rules which clearly lays down the process, and then selecting people who have the competence to lead the process. So most rules would have something like a principle built in whereby the party who delays has to pay up for the costs of the delay. And that is something that if you chose MCIA rules, for instance, even if you're arbitrating in India, you could choose MCIA rules, and it would become obligatory on both parties by those rules to actually expeditiously deal with the proceedings. So choosing rules also allows you for emergency arbitration. It allows you for expeditious hearing, document-only arbitration, various things that the rules have been carefully thought about through a series of experience you can gain from once you choose the rules. That apart, you could also look at having a good presiding arbitrator, and you should
allow the institutions to appoint presiding arbitrator instead of trying to have your arbitrators appoint presiding arbitrators. It would be beneficial because then you could have actually a greater quality. Institutions could appoint foreign arbitrators. There could be cross-pollination of ideas, and that's something that the parties could do it themselves by designing a proper arbitration clause.
Thank you very much, Sitesh, for that. There is some method in the madness which Nakul had painted out. We are, as you know, the topic that we have is delivering the best in arbitration, areas to focus in future. And what we are going to do actually is to walk through progressively in a process of futurology. And as Sitesh has kicked us off, by looking at what are the possible things that we can do to improve is an age-old question. This question of how do we improve time and cost and efficiency in arbitration, focusing specifically on the role of the arbitrator. We heard a little bit about that this morning, about the important role that the arbitrator has in driving the process, in making sure that the process is efficient, and both time-wise and also in terms of cost. So it's a very interesting take by Sitesh on looking at two aspects of this in terms of the role the arbitrator might take in actually facilitating a settlement of the process, if that would result in a saving of time, and of course, it also in how you might want to craft your arbitration provision in relation to that. Before we move on, I'll just say, if there's any other comment from the panel about this aspect about the role of the arbitrator in driving the process, in making sure that the process is cost and time efficient. Let me ask this question. Who would agree that it is a duty of the arbitrator to drive that process? Not leave it just to the parties, but to drive the process to make sure that it is time and cost efficient, even if the parties want to drag it out.
Okay, well, is this on? I had a comment, and that is, you can strategically use an arbitrator to facilitate a settlement in a particular kind of matter. Now, we've seen very often disputes between family members or partnership firms where the relationship is personal. Those can get very contentious very quickly, and there's a high emotional content to that which does not necessarily allow a practical or a commercial settlement outside of the arbitration proceedings. And I think that kind of a case is one where you can strategically use the arbitrator to be more proactive to facilitate a settlement. And that strategy could even be whether you make the offer for settlement before going to arbitration, and then posture, in a sense, before the arbitrators to say that we have made settlement offers which have not been accepted, which can then drive the arbitrator to coincidentally drive a settlement, or it gives you a better chance at getting actual costs should you succeed in the arbitration if the matter is not settled. Just to answer Stephen's question on duty, I think today, when time and efficiency and costs are something at the top of everyone's mind in proceeding to arbitration, I think every arbitrator does have an inherent duty to ensure that the arbitration is conducted in as efficient a manner as possible. So, I mean, I certainly think that they do.
Thank you very much for that contribution, Shaneen.
I just have a comment as a sort of an outside of the actual process. Just my simple point is that there's definitely a duty to make the process efficient, but it's also useful to make sure that they don't overreach in that duty. And I think what I mean by that is it's probably more relevant to a country like India, where it purely depends on who the arbitrator is. And if they're informed and they understand the process well, and the role different parties and different participants in an arbitration play, like experts. When that arbitrator is not well informed, it can be the opposite. It can actually make the process less efficient and less effective. And unfortunately, there's someone in the room here, we had a very strange experience with that last week, where they decided to dismiss expert evidence for no basis, which has now prolonged the whole process and pushed us back 3 months. So I think my only point as an outsider would be there is a duty, but sometimes parties know what they're doing, and they can actually make the process better and more suitable for the case they're involved in.
Thank you both. Now, I'm sure that you agree both with Shaneen and with Montek. And the reason why I am standing here and I'm not sitting there is because this is point browbeat number 3. Because what you're going to have next is a discussion, because that's what Shaneen wants to call it, between Shaneen and Montek on a point which they're supposed to differ. So at the end of their presentations, you cannot agree with both of them. You can agree with only one. And the topic that they're going to talk about is publications of awards, transparency or confidentiality. Now we're looking into the future. This is the future horizon. We're not looking at how arbitration has been practiced till now. We're looking at making arbitration a successful method of dispute resolution in the future. And the reason why I'm standing here, and this is why I'm coming back to browbeat number 3, is this. Shaneen said, I am going to sit in debate unless you stand up and come to the podium and make us come here. So I am here.
Thank you. So Nakul has really, I mean, that was a smart attempt at browbeating us, and I might as well tear up this one page of notes that I've made, because we have suddenly got guidance as to what we're going to do. So I'm going to play my solicitor card and overrule what my counsel has recommended, Nakul. And so what Montek and I are really going to do is have a discussion, seated, because I think it's much more civilized. And perhaps we will try and give you a for and against viewpoint, but we are also caveating that with, we don't expect there to be any clear winner, because I don't think it is a one or the other answer. We're also going to, in a sense, concentrate on India for the moment, because we've got the 2018 proposed amendments that are coming in, which changes the landscape of arbitration in a sense. So arbitration as a form of alternate dispute resolution, one of its primary characteristics is that it is private and it is confidential. And in fact, in the Queen Mary survey, which I noticed was very helpfully put in our conference pack today, about 87% of the respondents surveyed noted the aspect of privacy and confidentiality as being something that was very valuable in the process. It is also a forum which allows parties to air their views in a private manner, but we're not going to go into the arbitration procedure or the proceedings as a whole. I think everyone accepts that those need to be kept private, those need to be kept confidential. We are looking at whether it makes sense or whether we should agree to publish awards, or at least extracts of awards. Now, I think there are also, the answer also depends on the kind of user you are. So I am going to address this from the point of view of a legal practitioner, and Montek is going to address it from the point of view of an expert or a client. As a legal practitioner, of course, I think the answer is clear to anyone. I don't think that there is anyone in the room who would not like to see at least the legal reasoning in awards being published. Most complex commercial disputes today, and in fact, almost every single commercial dispute that is India-centric or has an Indian client, will be arbitrated. They are seldom going to court. Maybe you would find an exception for financial services contracts, but by and large, arbitration is the forum for resolution. And what you find then is that there may be 20 arbitrations covering the same issue. Say, for instance, something that is very topical and all of you will have heard of is the issue of put option and the FEMA regulations in India. Are put options enforceable? Is the put price enforceable? Is a violation of FEMA something that will violate public policy and set aside the award? Unless an award comes to a court to be enforced or challenged, which are which is one of the exceptions for confidentiality, you're reinventing the wheel every single time you go through the same kind of arbitration. So you may have the judge and the court laid down law available, but you also may have had 10 other arbitral awards which have dealt with these issues which you are not privy to. Of course, awards, we recognize that awards are persuasive, they are not binding as court precedents, and it is only at the stage of enforcement or challenge, if a court weighs in on the legality of an issue, that it becomes any kind of precedent. But at least the reasoning is there, the reasoning is available, it saves time, it saves costs, it's a best practice, it makes your arbitration more efficient. So I think that some amount of publication of a redacted portion of an award is recommended and advisable. Just, I should have actually, I mentioned the 2018 amendments earlier. So under the Act as it currently stands today, there is no express provision for confidentiality in arbitration. It only extends to conciliation proceedings. By the 2018 amendments, an express obligation of confidentiality to proceedings is attached, except where an award is sought to be implemented or enforced. Now, of course, implementation and enforcement would necessarily have to also involve challenge, but that is the exception to confidentiality. So it recognizes that in some cases, the confidentiality of an award would have to be released. Notably, while recommending the setting up of the Arbitration Council of India, one of the powers of the Council would also be to maintain a depository of awards, and that is both Indian and foreign awards. And if there is a depository, there is bound to be some sort of sharing of these awards. So that is also the intent of the legislature and the Indian government today. And you know that we keep raising our flag for ease of doing business, enforcing contracts, and this is one way in which we think it will facilitate. And similarly, of course, you all have seen the MCIA rules, which also provide for confidentiality, but allow the MCIA to publish redacted versions of awards, as several other institutions are also doing. So, just to recap, from a practitioner's point of view, I think there is good cause for publishing awards. And I leave it now to Montek to canvass the other.
While we had this banter, Nakul threw me into this conversation just 3 days ago. Before that, I was supposed to speak on damages, something which I know much more about. But while I have this opportunity, I'll try to do my best and make most of this. And I'll try to respond to some of the points, obviously also raised by Shaneen. She's already given me a heart attack with the number of points she wrote down.
I think that's your heart attack.
That's my heart attack. I guess the hotel agrees. I'll continue, I think. So I think just to kind of start off the premise, does everyone know what a tripod is, right? Something that holds an apparatus on 3 legs. And what happens when you break one leg, the whole thing falls apart. And often the camera on top of that breaks, right? So for me, arbitration is like that tripod. It's standing on 3 legs, right? The first leg being your right to swift dispute resolution. The second leg is party autonomy, and the third is privacy and confidentiality. Breaking one of those legs means the arbitration as we know it falls apart. And the reason what we're all here today, to celebrate arbitration and grow it, we should just go back home, because it won't exist. So I think, and that would be a pity. Because commercial arbitration, in my view at least, as an outsider, solves a very important market need, which is for quick, private, confidential, and effective resolution of disputes. Now, commercial arbitrations often involve private commercial parties, a dispute arising from a private contractual agreement involving confidential business interests and details. So it can only be fair that parties resolve those disputes confidentially, privately, without the unnecessary public scrutiny or any trial by media. It is not meant to be the public courts, and parties don't want to air the dirty laundry in public. And this is even more important when you understand the nexus of arbitration and contractual arrangements, where multiple parties are in multiple contracts and multiple jurisdictions. And confidentiality ensures that legal complications and disputes in one part of the world do not affect the other profitable ventures elsewhere. What we also haven't discussed is what happens to the data and information, including trade secrets, business strategies, business plans, which are often shared in those proceedings and often recognized and referred to in arbitration awards. Doing away with confidentiality will really prejudice the party's business interest, and in fact, in the extreme scenario, its survival. One extreme response to that might be lesser disclosure, which not always is a bad thing, but also what that might mean is the process becomes less effective. Now, I'll give you a simple example. As damages expert, we often rely on confidential business data to opine on question of damages. Now, what if that data was not available to me or available to me in a form I would like? By definition, my role is reduced, and by definition, the outcome will be less fair. So I think, and now coming to the issue of precedent value, and I think it's already recognized that in short, there is none. There is no precedent value in awards. And I think it can be persuasive, but the trick here is how much redaction must be done for the award to be published. Is it really useful, or does it just create more chaos and uncertainty? Will you suddenly see people using different awards in different places and different reasons? And again, it's not clear, right? It's not clear what value it's set. And one good example of that in investment state arbitrations. Most awards are public. Has it really solved the problem? I think it's created more, right? The definition of fair market value, definition of damages, it's still in linger. It's still debated hotly and still contentious in most investment state arbitrations, even though you could pick up and cite one of the 100 arbitration awards which are public. So it's not actually not clear will there be any value in having some of these awards published. What else can go wrong? I mean, look, you can also do what is, I think, was spoken in the previous panel, and I think it's an important problem which I think all of us should recognize, is going with the theme of investment state arbitrations. It's created camps. It's created camps for the respondents. It's created arbitrators for the respondents. It's created camp for arbitrators for the investors. And awards have unfortunately now become tools to get future appointments, right? Which is just purely unhelpful. Now, will that issue arise when you start making commercial awards public? I don't know, but it's an issue we must think about. Coming to even the role of experts, often it is debated that experts would benefit, the practice of expert evidence will benefit from seeing how other issues have been dealt with in other arbitrations. Again, it's really not clear to me, and the reason it's not clear to me, again, for two reasons. One being, again, it depends on how much information actually is made available, because often expert evidence and industry questions are very specific to the points you raise in a particular arbitration. They're very fact-driven. And awards often refer to the proceedings, the witness statements, the actual oral testimony. Now, if that's not available or redacted, it can be misinterpreted, and it can affect, in fact, future use of that redacted evidence. It also depends whether the awards, publicizing awards will affect the behavior of experts. Again, it's not clear to me. Investment state arbitrations, again, is a great example of that. You would expect experts to take less extreme views when their views are public, but that's not the case. You still see experts in investment state arbitration taking extreme position. So again, it's not been useful. So why will it be useful in commercial arbitration? And I just want to make one small distinction here, and I've got enough lawyers around me to correct me if I'm wrong on this. An important point here is confidentiality is not an absolute right in arbitrations. There are exceptions, clear exceptions. The three which I'm aware of are for public and state interest, to protect one's legal rights and by the order of the court, and by public consent. So you have the exceptions you need to ensure a more effective resolution of disputes. Do we need more? I really don't know. But I think the trend is more is good. Section 42 of the new proposed amendments deal with confidentiality of the proceedings in arbitration. Many jurisdictions have a much stronger view, like UK and Singapore. Some have a weaker view, like Sweden and Australia. But I think on the whole, it can only be a good thing. Thank you.
Thank you, Montek. I think what we'll do is this. We'll give Shaneen about 30 seconds to respond, maybe a minute. And I think if she thinks Montek's really strong with his speech, we'll give her 2 minutes. But that's really where we'll stop. After that, we will invite everybody on the panel to just chime in if they have any views of this.
Okay, so my response is not, Nakul asked us to take a black and white approach or a for and against approach. I think that is, I mean, this was fun, but we all know that that's not really possible. I think it's a question of marrying the need for confidentiality, as Montek says, of sensitive commercial information with the benefits of publishing an award for being better able to appreciate any kind of foreseeability or certainty in arbitration, including on whether you would like to approach the same arbitrator again, the kind of arbitrator he is. And sorry, it's not just awards, actually it's also procedural orders. Today our procedural orders in arbitration have become so complex, and often you're not quite sure how a particular arbitrator is going to deal with something. So it lends itself to some more certainty in the process. So Montek has a very clear point, and it's obvious, and as a client, I certainly don't want my trade secrets or my IP or any embarrassing or sensitive or commercial information out in the public. So if an award does not make sense in a redacted form after redacting this kind of confidential or sensitive information, perhaps that award cannot be published. But if it can, if it's on an issue of law or an interpretation of facts which are not commercial or sensitive or confidential, which would aid in the development of law, I think those are the kind of awards that would lend themselves to being published with some form of redaction.
Right. So let me just put a little teaser before we get comments from everybody else on the panel, because effectively I think what all of this is boiling down to is redaction. And my point, and I'm taking cue from what Montek said, is this: who determines how much to redact? Because I think we are all aware that if two people redact an award, they will do it differently, and the logic and the conclusion that comes out could be very different. And that could then lead to a completely different basis on which you determine what an award really sets out. Nitin, do you have any comments?
I said something this morning about the importance from the point of view of General Counsel, but there's another aspect of confidentiality which is equally important. As the courts and the judicial systems around the world retreat from scrutinizing awards, there is a greater need, in my view, for transparency. I'm with Louis Brandeis, that sunlight is the best disinfectant. The way you ensure that an arbitrator writes a sensible award is that his award is held up to scrutiny by the whole profession. It would prevent strange awards, which we've all sometimes seen, if an arbitrator knows that I'm going to get laughed at by the entire legal fraternity, and I'll never get another appointment again if my award is a bit silly. So from that perspective, putting aside the precedent value, transparency and publication of awards with the appropriate redaction is, in my view, a good thing.
I think whatever be the arguments against publishing precedents, it's going to in future have to be done to fill an important gap. As business becomes more international, finance becomes more international and multi-jurisdictional, no one party is going to be able to rely on one municipal court to settle commercial disputes, and we're going to have more of these international arbitrations. And therefore, how will the jurisprudence on commercial law develop? How will it get settled? What will be the guiding star, the compass for the parties to evaluate these cases into the future, I think is an important consideration, which the mercantile community, international arbitration community has to see as to what precedents they can, how the publishing of precedents can be done through proper redaction.
Thank you very much, everyone, for the contributions on this very interesting topic. Now, we're now going to continue down our journey on futurology. We've been looking at future solutions to current problems, and we're going to shift somewhat now to looking at future problems coming out of future technology. And we've got a perfect segue into this, because Nitin is going to talk to us about the use of technology to bridge common law and civil law approaches in document production. He's going to talk about the use of technology to solve an age-old problem.
Okay, there's supposed to be a PowerPoint, but is it coming up? Nope. Oh, okay, there we are. Well, let me go to slide 3. I've been told I've got a very short time and I must be succinct. That's very difficult for a person of Indian origin to be succinct. But if I may start, the basic problem, if I may start by stealing a phrase from the next debate, pendulum. I think arbitrations are like pendulums, and the instance I want to give is in the context of documents. When I started in this field in the mid-80s, and right up to the early 90s, document production followed the processes in court, and I practiced in a common law jurisdiction. It was comprehensive, it was enormous, all documents had to be produced. There was a continuing obligation to produce documents in arbitration. And the rationale for that is probably best given by Sir John Donaldson in the Eli Lilly case, where he said, and I hope there's no civil lawyers here, he pontificated, I should say, that that other jurisdictions may not have discovery, but in the common law jurisdiction, and I'm paraphrasing here, we have discovery and extensive discovery because litigation in the common law system is designed to do real justice between the parties, and if a court doesn't have all the relevant information, it cannot achieve this objective. Presumably, he felt that civil law jurisdictions, where there is a different approach to document discovery and document production, may perhaps have fallen short on real justice. But the theory is, and this is why I've drawn this chart, the common law theory is pursuit of an absolute truth at any cost. If higher cost is what it takes, that is a necessary sacrifice. On the other hand, the civil law have taken the view that it must be cost-effective dispute resolution, it must be quick, and as we all know, there is very limited disclosure obligations. In fact, there are no disclosure obligations, as I understand, in most civil law jurisdictions. I don't have to produce any documents other than those that support my case, and there's very limited discovery. But that makes it cost-effective, it makes it fast. That's the theory we're told. Now, the current paradigm in the international arbitration, of course, is set out by the IBA rules 2010, which to me as a common lawyer seems to be very civil law style, and it seems very civil law focused, and that there is no obligation to disclose adverse documents, there is no right of general discovery, there is only discovery of a narrow and specific category of documents subject to and even that is subject to considerations of procedural economy, proportionality, fairness, and equality. So the pendulum, as I say, when I started full discovery, it has swung to a very limited discovery in modern international arbitrations. Now, this to me follows civil law jurisdictions, but obviously the civil lawyers don't feel that because, as we all know, in about 7 weeks, we're going to have the Prague rules coming into force, and this is what they're suggesting right now, that the IBA rules, the Prague rules, which are primarily driven by civil lawyers, that the IBA rules are still closer to the common law traditions as they follow a more adversarial approach with document production. And that approach is castigated on 2 reasons. One, it is said that it is very rare, if ever, that document production brings a smoking gun to light. And secondly, if you go further down the introduction, it says that it's more efficient, faster, and cheaper to restrict document production. And what struck me as particularly Luddite in this approach is Article 4.1, the proposed Article 4.1, which says not only that the arbitral tribunal should avoid extensive production of documents, but it shall avoid any form of e-discovery. Now, I recognize that this is still a work in progress, and someone sitting on the working committee told me that this is still under discussion, but that is what they have currently published on their website, and this seems to be a further push towards the civil law tradition, that I prove my case with my documents, you prove your case with your documents. If you're lying, I can't ask to see your documents to prove that to be wrong. Now, as I say, it's a pendulum, and it seems to be swinging ever closer to the civil law jurisdiction. My thesis, if you like, is that there's a misconception here. Firstly, disclosure doesn't prevent expeditious determination. And I sit here as a Malaysian lawyer, and there's a Singaporean lawyer at the other end of this channel. They like to separate us. We're like Pakistan and India. We sit at opposite ends of the thing. In both our jurisdictions, there is extensive disclosure obligations which continue right up to the date of trial. But trials are generally completed within a matter of months, a year at most. There is some evidence, there are papers written, that the absence of disclosure obligations actually inhibits settlements. Settlements in international commercial arbitrations are said to be running far lower than the rates in courts. And even with disclosure, lengths of trials can be controlled. So if the objective is to control costs or time, it seems to me to be a misperception. But to the extent that the objective is to control costs, this is where we come to my modest little proposal, which is that technology is moving on. Almost all documents today are generated and stored electronically. Now, this has two consequences. Part of the reason why there could be extensive disclosure and discovery in the 80s and early 90s was because you had to type documents mechanically. There weren't a great many. The total number of documents you might find, even on a complex commercial dispute, would not exceed 20 or 30 bundles of documents. Today, you could have 1 million documents because of the ease of generating technology. But technology is also providing a solution, and that is e-discovery tools. I don't mean e-discovery in the sense of looking at metadata. I mean the kind of tools, the technology that has already been developed for due diligence of documents, where if you design algorithms or you design keyword searches that track through all the documents, the 1 million documents that may exist, and bring that down to a small number of documents, this would control costs. I can understand the concept that you don't want to have lawyers at their expensive time rates looking through 1 million documents, but a computer can do that and sift that down to 100 documents perhaps in a matter of minutes or hours at most. Electronic discovery would enhance the cost effectiveness of disclosure and discovery requirements. And this, it's my modest proposal, would dovetail the civil law and our current arbitration imperative of cost-effective dispute resolution with the common law quest for absolute truth. And in conclusion, I would just say that this is my thought of anybody who disagrees. Don't be a Luddite. Thank you.
Thank you very much, Nitin, for that very provocative, thought-provoking presentation. There's a lot in there that we could discuss, especially with what Nitin ended with, that the common law is interested in absolute truth, and the civil law is only interested in sacrificing truth for efficiency. But we're not here to talk about that age-old question. We're here to talk about what the future brings in terms of technology and how this will impact how we practice and how this may impact, whether this will bring together that age-old divide. I do have some questions to what Nitin had raised. Two questions specifically as to whether technology will really save us time and cost in this respect. First question would be, as Nitin was talking about, you need to build up algorithms. You need to design a process by which you would then go through this mass of information. Would there be, would this spawn a whole new area of dispute, which is over the algorithm, how it is designed, what are the factors that go in there, and would that then erode any saving of cost that you get from the computational power of the computer? And the second thing is also something that Nitin had picked up on, which is that previously there were less documents because it took a lot longer to produce these documents. Now it is so easy to produce documents, particularly emails. We are inundated with them. Would any saving of costs in terms of using technology to crunch through this mass of documentation be eroded by the sheer mass of documentation that we will have to deal with?
Technology. This is the person to ask about technology, I think. Yes.
Borrow this. So Steve, I think, what you asked is exactly what I intend to cover in my, presentation. But yes, today artificial intelligence has become so smart and, there are algorithms available. I think what you're trying to ask is that, who decides what's relevant and what's not, and, how do you pull out? This is a trial and error thing, but I think there are tools available and more are into the development stage. And I think as we move on to the AI, which I'm going to talk about, you'll see that there are smart technologies available to literally, crunch the hours and months of work into just few seconds.
See, in our unconventional way of doing this, we managed to segue this absolutely correctly to Kalindee, who is the last speaker, who's going to talk about artificial intelligence. Now, we are where we are. We're looking into the future. She's going to talk about the future, but her future on artificial intelligence and its use in arbitration presupposes one thing. And let me tell you what it presupposes. It presupposes that in the process of an arbitration, which is the filing of a claim, the selection of an arbitrator, the hearing, which comprises of the cross-examination, the oral submission, the reliance on all these bundle of authorities for precedential value, and most importantly, for the delivery of an award, there is a fundamental basis. And the fundamental basis is the exercise of human intelligence. I don't know if that is correct, but Kalindee will tell us whether artificial intelligence is going to take that over.
So Nitin, I think, big thanks for setting out the entire context. I won't have to do a lot of work on that. So I have a very interesting and a colorful presentation. I thought, we would be doing it post-lunch, and maybe this is the last session. I definitely don't want everybody to be taking a little nap. So, I think picking up from where we were discussing, every day we are reading in the newspaper that, AI is coming, and AI is artificial intelligence, and it's really going to change the way we work, change the way we do business, it's going to change the way we think as well. AI today is used literally everywhere. It's used to predict the customer's buying pattern. Pharma companies are using it to do, diagnosis of the patients and, how they can prevent disease. And the beauty is that, there are extremely sophisticated applications available to perform the most complex task in just few seconds. However, it does not eliminate the human intervention, but it definitely makes it quite limited. So what is artificial intelligence? In all the words, simplistically put, artificial intelligence is making machines behave in a way that would be called intelligent if humans were to behave that way. And I think machines typically rely on two languages. One is the natural learning and the other is machine language. Natural language is what you and I speak and what they can pick up in terms of speech recognition, accent recognition. And machine learning is how the data operates in terms of creating the pattern. I actually wanted to quickly touch base on what we do in the traditional way of the arbitration proceedings. We would look at tons of data, analyze the contracts, maybe analyze similar other contracts to find if there were variations, look at who would be the probable arbitrators who can decide the matter, whether they are experts or not, whether they are conflicted or not, drafting the petition and doing a whole lot of work that goes in. You guys are experts, so I don't need to dwell too much into it. But I'm jumping into the areas which can be influenced by AI. And the first point is legal research, right? I mean, what Nakul asked, that how much time do you take to literally go through the tons of documents and the discoveries that you would have collected if you were to do it manually. If you use the AI, you can literally crunch that time into just few days or maybe a week at the max. Yes, you need to give the correct instructions because it's a machine that's processing. So unless and until your keyword searches are appropriate, the machine will not throw up the right result. AI is also these days used to give you drafting recommendations. So it generally picks up a lot of standard clauses. I mean, we have the traditional templates that we use. First couple of clauses are standard, couple of prayer clauses are standard. AI will help you to pick up those standard languages. It will also help you to evaluate what are the weaknesses in your case so that, the lawyers can work a little bit more on that area to ensure that, they cover it well and, they put enough emphasis where there are gaps. AI will also help you to recommend which is the best legal team you can put up to defend the suit. So it would mean in terms of, who your pleading counsels are, who are the teams, and this is pulled out from, the past results, who is the arbitrator, which jurisdiction, which governing law, and at times it can go as far as predicting the outcome. So there are, softwares which predict that, if you are fighting a suit in a particular location, whether it's litigation or arbitration, depending on who the arbitrator is and which laws apply and the merits of the case, it can very closely predict what's going to be the success rate. This is from the legal perspective, like if you are going to be pleading the case, how does it help the arbitrator? So with respect to the arbitrator, it helps them in making the entire process fast and efficient. So when you give the, tons of documents in terms of submissions, written statements, rejoinders, it helps to read those clauses, identify what's the most relevant area where the arbitrator needs to decide, framing of the issues, and, create a summary of what the real problem is. AI can also be used by the arbitrator to dictate the orders, like, they can dictate lengthy orders, and the speech recognition tool will type it out, and, it cuts down the entire time between the way he starts understanding the issue and by the time the order is ready for publishing. Again, it, gives you the recommendation of arbitrator. I think I covered it under the earlier case, and it gives you a lot of administrative assistance in terms of summarizing the order and everything. Now, there is also a talk in the technology world where I live that can we have AI, only AI as arbitrator? And it's being heavily debated in the space because people believe that, for a lot of simplistic cases, there are standard set of issues, there are standard set of submissions, and there are standard set of outcomes. So can we completely eliminate the human intervention? The answer to that is slightly, there is no right or wrong answer as of now because, while the technology companies are trying to push for more and more technology usage, there are concerns available because the thought process is that, what a legal mind can think. Like if you are an arbitrator, even if you are going to, delegate somebody to write the order, it's going to be assumed that, you are delegating your mind and you are asking somebody else to write that. That's not what we would expect as lawyers or, as citizens of any country. So if the machines are going to make those decisions, will that outcome be fair and reasoned decisions? Will the machines be able to, deal with the emotions and empathy? Whenever we are litigating, I think Shaneen mentioned that, at times there are disputes between families and partnerships. There are a lot of emotions that are going into the whole process. Will a machine be able to understand the emotion and, give a fair outcome of it? Is human touch really important? The answer to that is undoubtedly yes. Algorithms work on the quality of data that is fed into it. So if you put a bad data, you get a bad outcome. So the human inefficiency still does not get completely eliminated in the process. And the last part is that, there are interpretation challenges. So I think I've put a slide which says that, okay, we need something, and what's thrown in by the AI is, little out of the ordinary. So the last part is that, what is the risk of AI and how do we mitigate it? So there's a lot there's still a lot of uncertainty about the precise impact on the labor market and the time horizon in which change will occur. So it's important to be honest and say that while we believe AI has incredible potential to make the world run better and improve people's life, there are, always have been, and will continue to be people who are adversely impacted by the technological change. There's also a need to recognize that the changes brought by AI will most likely take shape just as any other major technological development throughout the history, where new jobs will be created in place of the old one. At SAP, we believe that it's the responsibility as technology company to ensure that we fulfill the tremendous net positive impact which AI can have by creating products which allow people to enjoy their jobs more, focus on the things that they are good at, and drive the type of innovation which will continue to create more jobs. I don't want to spend too much time on this, but maybe just very quickly. So, and it's not a sales pitch, I'm just talking about, how diligent technology companies are, and a lot of companies have come up with, but I think SAP was the first one to publish. So we have come up with the guiding principles for AI. So we do a lot of research and work on AI and how things will shape up. But we have promised to our customers and to the society at large that we will be committed to be driven by values. We will create designs for people. We will ensure that there are no biases which come into the AI processes. Will be transparent, and there'll be integrity maintained, which shows that we'll be publishing what this product is meant for, what it is supposed to be, what we call fitment for the purpose. We'll uphold the quality and the safety standard, and if something is meant to cause any harm, we will not do work on those kind of innovations. And lastly, we will protect the data confidentiality and privacy, and resolve that there are vital social challenges which are worked on. So I think with that, I'll just end my.
We should get that last slide. I think it's a
yeah,
really
yeah,
cool
sure.
slide.
Absolutely, yes, I completely missed it. So this is just to end on a lighter note. What could be the side effects of having the AI? So it says, are you really scared of artificial intelligence? No, the concern is that there's a decrease in the real intelligence. Do we miss the natural human stupidity in the AI? And the last one is, call me a cab.
So now you figured why I said I don't know whether what we do is intelligent or not. I mean, I saw Kalindee's last slide, and it made me wonder what AI is looking at taking over. But on that note, let me just hand this over to Stephen to ask,
Well, so I hope that you have now seen the method in our madness. We've walked through a journey in futurology. We've looked at future solutions, possible solutions to current problems, and we've ended up with a glimpse into the brave new world of artificial intelligence, and perhaps the stark realization that in future we may not have arbitration conferences like this with you and I sitting here. We would have a room full of machines just talking to each other, and we'll all be redundant. And on that somber note, though, perhaps we have time for just one question, if there's any. Please.
I just wanted to make a quick comment. I know we're out of time. A quick comment and a question about the discussion or the debate regarding the transparency and the issue that as it's usually presented, at least it seems to me, is the concern is that the development of common law bodies of law is being stunted by the sort of shifting of a large volume of commercial disputes into private arbitration. And that seems to be a very legitimate concern to the extent your concern is of the development of Indian law, English law, Singapore law, New York law. But arbitration clauses, I wonder to what extent this would, the proposals that are out there would solve that problem, because arbitration clauses don't designate lex mercatoria, they designate Singapore law, Indian law, English law. And you've got a contract governed by English law, say, and an award is rendered by a Singapore lawyer, a Korean lawyer, an Australian lawyer, even if they were fully transparent and published as a judicial award, as a judicial decision would be, what standing would that award have as a pronouncement of Singapore law, Indian law, whatever the case may be? And so I wonder whether the medicine, which I can see at a gut level, I can see the value in it, would be worse than the disease in the end.
Thank you very much for that comment. It's a very good point made that perhaps the value of publication of awards may not be so much in dealing with substantial legal issues, but with more procedural issues in arbitration. But I think with that, I think we really have to bring this as a big red stop sign being flashed at us. We really have to bring this to close. So please join me in thanking all our panelists for that very interesting discussion. Thank you.